Good evening, everyone, and welcome to another edition of my legal weekly presentation where I try to help people with legal issues and provide information that's very, very important for things that we may encounter on a regular or not so regular basis that involve accidents and injuries and stuff like that. I am attorney Chris DeBari, and I have been practicing in the Tampa Bay area for 20 years. I help people who've been injured in motor vehicle accidents, slip and fall accidents, and other premises liability type injuries. If you like what you hear today on my presentation, please feel free to press the like button. Also, feel free to comment and share this information. And I do appreciate your criticisms and your feedback. In fact, like I've indicated every week, pretty much, I often dedicate entire segments to questions that come up among my viewing audience and among my friends and colleagues. Today, we're going to talk about an area that I practice dealing with premises liability. Now, premises liability basically includes claims where a person is injured on another person or another entity's property. In Florida and in common law as well, there is a duty that a landowner has to persons on the landowner or the land occupier's land. And that scope of that duty generally depends upon the purpose for which the person is on the land. And by the person, I mean the person who is eventually injured on the land. The duty that is owed to them by the landowner depends upon their status on the land. And if a person is injured on someone else's property, on someone else's land, or in someone else's department store, then based upon whether or not the landowner can be considered to have breached their duty, the landowner could be responsible for the injured person's claims and injuries. Now, normally in an ordinary negligence claim, people have a duty of reasonable care toward other people. When you're operating a motor vehicle, you have a duty to operate it carefully with regard to other drivers. When you're playing sports, when you're doing anything that involves activity that could potentially endanger other people, you have to behave with reasonable care toward other people. That's a very general rule of negligence. The difference between an ordinary negligence situation, like suing somebody that rear-ends you in a car accident, and a premises liability case is, in the auto case, as in most other areas of negligence, the duty that we have to use reasonable care is absolute and doesn't have any respect to who somebody is that we might hurt. Fact of the matter is, if we're engaged in a particular activity, we are presumed that we're going to be reasonable in the way we carry it out. Oh, my mother is on. Hi, Mom. How you doing? Thank you for saying hi. Thanks for being here. My most ardent supporter. But in the case of a premises liability injury, the duty owed can grow or shrink depending upon the status of the person on the land. And by the duty, I mean that duty that is owed by the landowner or the occupier of the land. So now Florida recognizes, and as does common law, but Florida in particular recognizes that there are three types of people or three statuses that a person may have on the land of a landowner or land occupier that could potentially shape the extent to which a landowner has a duty toward them. Now, the three types of status are: you can be on the land as an invitee, as a licensee, and as a trespasser. Now, an invitee often fall into two separate categories. They are usually people that are invited onto either businesses to conduct business or to further the business's purposes, such as like a supermarket or Target, or even like a Buck Stadium, something like that. And you also have public invitees, and public invitees are people that are invited onto public land for the purpose of furthering the business of the public. And this could be something where people are going to vote. You're on the voting premises for the purpose of something that has to do with being invited on for a public purpose rather than a retail or business purpose. So when a person is on the land and they're invited to transact business or for a personal reason, the owner of the property or the entity occupying the property, they basically have a twofold duty to the people who are on their premises, either as public or business invitees. And that duty includes protecting the invitees from dangers which they should be aware of. So if this is a danger that a landowner should be aware of in the exercise of reasonable care, then they have a duty to protect the invitees from the danger. And we call that attenuation. So if you have an awareness of a danger as a landowner, then you have a duty to not only be aware of it and perhaps warn about it, but you also have a duty to keep the invitees away from the danger. The other is to warn of any dangers that an invitee may not experience or may not discover through the use of their senses. So that's a twofold purpose. You have to not only make the premises safe and protect your invitees from known dangers, but you also have to warn them about dangers that they may not detect through their own senses, that they may not have reason to be aware of. So there's attenuation, and then there's also notice. And those are two things that an invitee is entitled to under Florida law. Now, the next class of person who can be found on the land is what's called a licensee. Unlike an invitee, a licensee isn't necessarily on the property to further the interests of the business owner or further the public interest. An invitee is usually, or a licensee is usually somebody that's sort of on the premises for their own purpose. It could be walking across a gas station parking lot to shortcut the sidewalk. You don't want to walk the 90-degree angle, so you cut through the parking lot. You're not really a trespasser, but you are a licensee. You're not a business invitee because you're not transacting business. And if you were to go in that gas station and get change of a 5 or a 10, that really isn't furthering the business purpose. That's furthering your own purpose, and you're really just a licensee in that situation. And the duty that's owed to licensees is basically that a landowner has to avoid willful or wanton misconduct toward them, and not expose them to any hidden dangers. So, a landowner will have a duty if somebody's coming across the property. If the landowner knows of a dangerous condition, you better get out there and say something or have some sort of sign up to warn both business invitees and licensees of the presence of a dangerous condition. Suppose you're walking across the gas station parking lot and there's a leaky gas pump or something like that, or fumes, something, warn people don't light lighters, don't light cigarettes. That's an example of warning people, although you figure they should know that around a gas pump. But if in particular there's an even greater problem, then you have a duty to warn not just the invitees, but also the licensees. So, a licensee has not quite the status of an invitee, but you have situations where a licensee may decide after walking through the parking lot, well, I'm going to go in there and I'm going to buy a pack of gum, I'm going to buy a Coke. Then they go from being a licensee to being a business invitee. So, the status of the person on the land can change from time to time. And of course, the last type of status a person can have on land is being that of a trespasser. And as Jason Keene, my friend, indicates, he has a plan for the trespasser. Yeah, Jason, I bet you do. But maybe this would have an effect on that. The duty that's owed to a trespasser is basically not to engage in willful or wanton conduct to bring harm to the trespasser. A good illustration of this would be like not to set traps. One of the things that Professor Lake at Stetson taught us in law school was the spring gun case, where people had a spring-loaded shotgun pointed at their front door or at their window, and if somebody broke into the house, the gun would go off. Now, even though these people are breaking into the house, you're not home protecting yourself. You're just protecting your property, and you're not allowed to use deadly force to protect your property. At times, you can use it to protect your person in your home. But as far as setting up traps for trespassers, you really can't do that. In fact, there is an argument also that if a person is a trespasser and their presence is discovered, then the landowner may have a duty at that point in time to warn them of hidden dangers that the trespasser may encounter. So once the trespasser's presence is known, the landowner may have a duty to warn them about something dangerous that they may not see because it's hidden. So it sounds kind of unfair, somebody trespassing on the land, somebody just trying to indulge their curiosity, or maybe doesn't necessarily mean you any harm, maybe not break into your house, but you don't really want them there and they really don't belong there. And of course, once you tell a person from the land that they need to get off the land or have the police do it, they then become a trespasser. And of course, there are times when invitees or even business or licensees can become trespassers if they overstay their welcome on the property and they refuse to leave. They are then trespassing on the property. And obviously, at that point in time, the landowner's duty of care is just not to engage in willful wanton acts and also to warn them of hidden dangers. But now, the most common forms of premises liability, and this is the stuff you probably see and hear of the most of the time, is slip and fall or trip and fall type of incidents. And we see these in Walmart, we see them in Publix, Target, Whole Foods. You go into an establishment and you trip and fall over an item of merchandise, over a substance on the floor, and you're potentially injured, then you may have a right to bring a claim against the business owner because the business owner had a duty to attenuate you from the danger, basically make the premises safe and keep you away from any known dangers and also warn you of the hidden dangers. Sometimes the things that happen in supermarkets and in department stores may be conditions that are not caused by the landowner. And, well, why should the landowner be held responsible? Well, if you can demonstrate that the landowner had constructive knowledge of a dangerous condition, particularly even one that they may not have caused themselves, then the landowner may be held responsible. A good example of this would be, suppose a kid spills his juice box in Publix on the floor, and you're walking through and you slip on the puddle and you land on the floor. Well, Publix may be held responsible if you can demonstrate that Publix had reason to know that that condition existed for a period of time. If there's nothing to show that Publix had no reason to know where the substance came from, but if you're lying on the floor and you see that the apple juice has cart marks and footprints going through it to suggest that people have transgressed over it, maybe for a period of time, that makes it more likely that Publix had constructive knowledge, meaning that they should have known of the particular incident. This comes into play often in the transitory substance cases. Transitory substance cases essentially are any type of liquid or solid object that's on the floor that causes somebody to slip and fall, and that maybe have been introduced by another person. It may be introduced by the fault of the store itself. But it used to be before 2010 that the plaintiff would just have to allege that the dangerous condition existed and cause them to fall and get hurt. However, and then the burden, obviously, the defendant would then have to demonstrate, based upon the plaintiff's allegations, that they behaved reasonably, that they maybe inspected the store at reasonable intervals, that they did their routine cleanup, because you may not always hold the defendant responsible just because something happens in the store. There has to be some element to show either that they were responsible for causing it or they were responsible for removing it in a reasonable amount of time and that they failed to do that. But with the transitory substance statute changing in around 2010, 2011, the plaintiff now has the duty to establish that the defendant behaved unreasonable before the defendant is then in a position where they have to rebut the allegations by the plaintiff. So that's a very big thing that changed. In fact, the duty on the part of the plaintiff to show that the defendant knew or should have known of the dangerous condition was something that caused a little bit of a stir, because there was an argument between whether or not that was a substantive or a procedural change in the transitory substance statute. So basically, if a change in the law is procedural, then it can only affect prospective cases, meaning cases that occur from the enactment of the statute forward. However, if you can demonstrate to the court's satisfaction that a change in the law is substantive, then you can prevent its retroactive application against cases that already exist. So if a substantive change comes along, it could potentially affect cases in the past. However, if it's merely procedural in nature and not substantive, then it's not going to have that effect. So Paul Bernardini is here. Hey, Paul, how you doing? Welcome. If a trespassing child jumps on a properly built fence pool enclosure to go swimming and drowns, can his parents sue the homeowner? Well, you can always sue the homeowner. I mean, all you really need to sue somebody in Florida is a complaint and a filing fee. However, a child trespassing, jumping onto a properly built fence, that's a very difficult issue, and probably one I'd have to do a little bit of research on before I could properly answer. But this seems to be one of those times where you have the attractive nuisance doctrine, which could potentially get involved, whereas the homeowner may have to do a little more than just fence the pool in. But once again, that would be a question for a different day, and I thank you for asking it. I could actually probably design a whole presentation around that. But these premises cases are very, very interesting. They're very frequent. And one of the important things to remember, too, is if you were injured on someone else's premises, you need to do certain things. And it's not always easy to be present in the moment when this stuff is going on. You're maybe hurt, you could be stunned, you could be embarrassed, but it is important to collect information. I know you may be thinking it's kind of counterintuitive. You're not in any position or any state of mind, but it's very important to kind of keep it together. And you want to get the names of anybody that may have witnessed the slip and fall or the trip and fall or the incident on the premises of another. You want to get their names. You want to make sure that the retail establishment, the managers fill out an accident report, that it's accurate. You want to make sure that the persons who witnessed this information is taken down and identifiable so that you can find them later on. And don't trust the store manager to do this. They are notorious for not doing this because it doesn't serve the interest of the business for all of this information to be preserved. Remember, as time goes on, evidence disappears and your case gets worse and worse. So it's incumbent upon you to document the scene, take pictures of the substance, take pictures of the spill on the floor. If you're walking into Home Depot and it's raining out and they don't have rain signs up and you slip and fall, and some people can say, you know, in a situation like that, well, it's the person's fault. They should have known that it was wet out because it is raining out. Well, that's beside the point, because suppose you were to walk into walk into Home Depot and it's raining and it's wet near the front of the store, and you wander to the back of the store, you do your shopping, you find what you want, you're wandering back to the front, and you've forgotten the fact that the floor might be wet, and you're distracted by the displays and the things that the business is trying to sell to you. You may not have that in mind, and that's a situation where having that sign there would be a reminder, and you could potentially implicate the business owner as being negligent for failing to warn in that scenario. Also, if they're aware that water accumulates in certain areas and that mats would be beneficial and that they don't put mats down. There's one particular gas station chain that I've sued many times that they do not use mats, and they can never explain why. In depositions, they always talk about how the studies have shown that the mats are unsafe. However, they're never able to produce the study. And essentially the mat, which is sort of a segue between the outside and the inside, a place to perhaps dry your feet off or at least step off of to test the slippability of the floor, is something it's just not there. And many slip and falls can occur because of that. So there are things that you remember, document, but there are also things to notice as well. Were there wet floor signs up? Were there mats up at the time? And obviously, one of the things we as attorneys do is we request that a potentially liable business owner preserve video of the scene that may have recorded the situation or may record the dangerous condition as it existed at the time of the injury. But that's pretty much it for today. I just wanted to discuss the status of people on the land and premises liability and a couple of pointers. There is actually one more thing. I'm sorry. Some people say, well, they must have known that it was dangerous because they fixed the condition right after that, and the jury gets to see that, right? No, not necessarily the case. In Florida, a subsequent remedial measure taken by a landowner is generally not allowable to prove that they were negligent in the way they conducted the business leading to the injury. So any correction to a dangerous condition that's made after an incident happens, even if it's done completely openly and you can take a picture of it or whatever, it doesn't make a difference. Subsequent remedial measures are encouraged by landowners to take. And otherwise, if they didn't do that, and if you were to hold the landowner liable for fixing the broken condition afterwards, you would simply discourage them from doing that and potentially expose more people to harm. So the subsequent remedial measure restriction has a actual legitimate public purpose. But anyway, folks, that's it this evening. Thank you for tuning in. Thank you for your questions, particularly Paul, and your comments, Jason. Hey, Barbara. I see Barbara Niswanger is there as well. Thanks for stopping in and listening. And like I said, if you like what you heard today, please share it. Please comment. Smash the like button too. And appreciate that. And remember, if you ever have an issue where you or a loved one have been hurt on someone else's premises, have them call the Law Offices of Christopher DeBari at 727-656-7852, or you can check out my website at CDB Injury Law, where you can contact me through the website. Thank you very much and have a lovely evening.